On behalf of the signatories to the document that's been handed to you, apologize, it's handwritten. The decision was made this morning to serve a petition for reconsideration of the decision on the Mountain Valley Pipeline. And the reason we're doing this today is because of the nature of the comments being made and heard today on the Atlantic Coast Pipeline, and that you might properly be having some second thoughts on your decision, and we're giving you an opportunity.
Excuse me, is this new information?
This doesn't have anything to do with ACP, which is the purpose of today's meeting. This is not...
It does have a purpose.
This information is not currently in the record. It has nothing to do with...
It has relevance to the ACP because of the nature of the instruction the Assistant Attorney General gave to the board. We are concerned that the same is going to be given to the board today. At the conclusion of the meeting, there was concern about the lack of information necessary to base your determination. There was a request made by a board member to clarify your authority.
This is not the topic. This is not what we're telling you about today.
I disagree with the chair of the board because of the nature of the instruction from the Assistant Attorney General, which was intimidating. The public could not hear what he said. We request instruction that is given to the board at the conclusion of this meeting be made in an audible manner that the public can hear and understand. We believe that what he to find every other decision that had been made on other permitting actions to be unfounded, or for you to somehow criticize those understandings. I want you to know that no one else except the Virginia Water Control Board, the State Water Control Board, has the authority to issue a certification on the reasonable assurance of water quality in Virginia. FERC does not have that authority, and the Assistant Attorney General led you to believe that they do, and they don't. The Corps of Engineers does not have the authority to issue certification on the reasonable assurance for the protection of Virginia's waters. Only you have that assurance, and your decision in this case and in the MVP is independent of any other action that has gone heretofore. There is nothing in the FERC environmental impact statement on the ACP that has anything to do with. You cannot rely on FERC. You cannot rely on the Forest Service. The Forest Service has no authority under the Virginia Water Quality Standards. It's your authority. It's your duty. I would like to state that I would like to state and support my agreement with Richard Averett's comments, my agreement with Nancy Sorrell's comments, all of the comments of the people who live and work on this land that delivers all of us clean water. And it's your duty, and I request that you make sure that your advice is clear and sound, and you understand the bounds. We're asking in this petition for reconsideration that your decision be made in accordance with your authority under Virginia regulations, and they're stated in the petition.
For advice on whether or not Mr. Linsky's comments just now were relevant or pertinent to this proceeding?
Whoa! You believe they're relevant? Say aye! Aye! Whoa! Looks like we win!
answer your question, no. Today's agenda item pertains solely to ACP, not EVP.
Mr. Chairman, I move that the petition for reconsideration and Mr. Linsky's statement be struck from the record of this proceeding.
You've been served with a petition. How can you strike it?
I object to that motion to strike this. I would like to move that we continue our hearing.
Thank you, Roberta.
Got the floor. What's the motion?
Madison County. Why has the respected VA DEQ in recent days felt the need to stoop to the level of EQT and Dominion's corporate spin before the media and this board? In regards to the Mountain Valley Pipeline, they stated that there are already more than 2,000 miles of natural gas pipelines in Virginia as justification for a permit for the MVP and presumably the ACP. How many of these 2,000 miles are 42 inches in diameter with a maximum operating pressure of 14 square inch? How many miles of such a pipeline exist in the western slope of the ACP's proposed route? How many miles of any pipeline in Nelson County? The answer is 0. Is it possible that other companies acknowledged facts about the terrain of Highland, Bath, Augusta, and Nelson that Dominion has refused to admit to? Why has the VA DEQ produced a summary of the prior proceedings that lacks any solid details of site-specific information that residents along the route could comment on? Why are such key questions like slope stabilization during and after construction being left to the actual construction phase of this project? Using Dominion's numbers, 90% of the Nelson route is on slope terrain, and more than 80% of the Nelson route Dominion has expressed revegetation concerns for. The VA Department of Emergency Management has cited all counties along the western part of the ACP route as high risk, moderate incidence for landslides, and yet there has been no site-specific analyses. The VDEM also specifically cites as high risk for these same areas. USGS Report 99-0518 recommended after Camille that local ordinances be adopted to protect Nelson County slopes, an event that took 125 lives. And the U.S. Army Corps of Engineers still had boots on the ground doing stream channeling work in Nelson 2 years after Camille, and yet no site-specific analyses. Analyzing these issues during construction will not ensure slope stability, prevent runoff, or meet the standards for erosion and sediment control in terrain with bedrock as shallow as the already damaged slopes of Nelson. Similar conditions exist all along the ACP route through Highland, Bath, and Augusta. Why did the VA DEQ abdicate its powers to protect Virginia stream crossings to the U.S. Army Corps of Engineers when the number of stream and river crossings for the ACP is really high? are citizens to believe that this is not an attempt to abdicate responsibility and liability? Who will be held accountable? We are already keenly aware of the gross construction violations in the states of Ohio, Pennsylvania, and West Virginia with the construction of the Rover and Mariner East pipelines, and the dismissive hands that these companies have waved at the state environmental agencies. Rover Pipeline is currently refusing to pay the fines levied by the Ohio EPA for scores of violations. Has the VADEQ been smarter? Is this board willing to risk that they have? Following the MVP hearings, why was the VADEQ quoted in news stories as saying that they had actually spent more than 2 years reviewing these pipeline projects to ensure that the permits would stand up in the courts? Preventing these projects was never supposed to be the DEQ, and I'm guessing that dedicated DEQ rank and file employees are not happy to be represented to the press in this manner. Protecting Virginia's waters and resources was to have been the entire point of DEQ's review. And if the state agencies that approve these projects are not accountable, who will be? The MVP and the ACP are both limited liability corporations, risking only the assets of these newly formed companies registered outside of the state of Virginia. Will the U.S. Army Corps of Engineers be accountable? To date, having permitted Rover Pipeline under the same nationwide permit applied for by the ACP, the U.S. ACE has remained silent and uninvolved in Rover's countless violations. I implore this citizen board to have the agency reviewing these projects has failed to do for the past 3.5 years. I respectfully request that the SWCB do its job and make protection of Virginia's waters and resources a top priority. I ask that this board ACP's permit until all the construction plans and site-specific analysis are and fully reviewed. North Carolina's environmental has repeatedly requested additional information from the ACP and is sending their 401 certification until issues are resolved. It's not the Hold Dominion strong-arm tactic and is not driven by the ACP's construction.
County and a current president of Friends of Nelson, who's been working tirelessly for 3.5 years to stop the Atlantic Coast Pipeline. In January, I'll take my elected position representing the citizens of Nelson, and I will take an oath to maintain Nelson County as a beautiful, safe, healthy, and prosperous rural community. I take my oath of office seriously, but as a witness to the previous 2 days of public testimony and the deliberation and conclusions of this body last week, I can't realistically consider the Commonwealth of Virginia an ally in this mission. Refused to meet with a single community interest group, environmental protection group, historical society, scientist of Nelson County, who has expressed reservations with or articulated the significant impacts of the Atlantic Coast Pipeline. He's deserving of every ounce of criticism and anger of his constituents, whose honest, articulate, and with locked doors and deaf ears. His actions have been unconscionable. The DEQ and this body have a more specific purpose than the governor. I was witness to fully informed and educated public comments last week and today. Every soil scientist, every water quality expert, every geologist, every karst expert without exception presented clear evidence of how and why the MVP would compromise Virginia's water quality. Yet the DEQ and the Water Control Board chose to defend the right of Mountain Valley Pipeline LLC to degrade Virginia's water quality in hundreds of ways, rather than to protect the rights of our citizens to clean water. I was witness to the regulatory agency to fulfill their mission. I was witness to a flawed, unprofessional process that was more concerned with maintaining control than with protecting water. It's unfortunate that citizens must take it upon themselves to protect their homes, their livelihoods, and their precious water because of the oppressive actions of the Commonwealth. But you must understand that when our government fails, it's our right and responsibility to do everything we can to make things right. We will continue to inform the public and to provide unbiased data to decision makers. We will testify at hearings. We will submit comments. We will exhaust our administrative remedies. We will take legal actions. We will confront greed, avarice, economic privilege, and oppressive power in every way that we can to protect our water. It takes the work and dedication of many to protect Virginia's water quality. We ask that you join us in this effort, but do not expect us to join you in shielding those who would use their political influence to take our water and to pollute and degrade our water to serve themselves. Thank you.
Which is a non-profit environmental law firm. The DEQ is here asking members of this board to determine whether the Atlantic Coast Pipeline meets Virginia water quality standards. The DEQ is not charged with and may not make that determination, and it certainly may not make that determination after the water quality certification has been issued or granted by this board. The board has the ultimate responsibility to determine that the certificate will assure compliance. The board has the ultimate responsibility to determine that this certificate will assure compliance with the water quality standard. The board must have relevant and information and analysis before it at the time that it issues the certification, not afterwards. It may not issue the certificate and then allow DEQ to later determine that water quality standards will be met and that sedimentation won't degrade streams. But that is precisely what this board allowed last week with the MVP. I therefore respectfully ask this board to reconsider the infirmity of its action of last week and to reach a different conclusion this week. Ralph Waldo Emerson famously said that a foolish consistency is the hobgoblin of small minds. Despite its action on MVP, I ask the board today to deliberate with an open mind and heed Emerson's statement. The legal argument that the 401 certification proposed here today is legally impermissible is, I think, unassailable for at least two reasons. This board cannot be assured the AC will comply with water quality standards until, 1, after the DEQ completes the erosion and stormwater process and analysis, and 2, until after the anti-degradation provisions of the water quality standards have been satisfied. It is axiomatic that any decision of an administrative body like this board will be arbitrary and capricious if there is not a rational connection between the facts found and the conclusion reached. Here, with ACP, the relevant facts haven't yet, because DEQ hasn't completed its ENS review, so it is impossible for the board to reach a rational, non-arbitrary conclusion until that review is complete. The board simply does not have the factual basis to make a rational decision before DEQ has completed its work. There are many outstanding issues that the DEQ admits that it has not yet considered, and particularly important is its analysis and approval of the erosion and sediment control plan. Rather than do its work and then ask this board for the 401 certificate, DEQ would lead the board to a rush to judgment. Again, the board may not legally certify the FERC license until the information allow it to make an informed and rational decision. So that cannot happen until the ENS process is concluded, and I understand that will be sometime in February or March. Syllogism. The board may not legally certify the FERC license until it can conclude that there is a reasonable assurance cause a violation of water quality standards. That showing cannot be made until the erosion and sediment control plan is approved. That plan has not been approved. The board not the ACP not quality standards, and it must deny the certificate. Further, a denial of this certification would not be a fatal blow to the ACP. Forget whether it's with prejudice or without prejudice, it's essentially without, because there's no question that ACP can resubmit its certification request, but it can submit it when it's ripe for consideration and not before, only after the record is sufficient to support its request. Accordingly, this board should deny the certification with the understanding that it will take up another request from ACP after the erosion and sediment control plan has been carefully considered and approved by the DEQ, and after the anti-degradation provisions have been complied with. In addition to its failure to perform the ENS analysis and any degradation review, the DEQ improperly relied on Nationwide 12, the Corps' permit or authorization for pipeline crossings, which makes it impossible for the board to fulfill its duty to determine the impacts of those crossings in combination with the upland discharges. Again, the DEQ's job is not complete, and the board does not have sufficient information before it to make an informed. DEQ and this board may not rely on Nationwide Permit 12 authorization because the scope of that authorization is legally limited to the impacts of the crossing itself. The scope of your certification, however, is for the entire pipeline and all of its impacts. Remarkably, there are yet no sediment load calculations. We don't even know the extent of the variances that will be proposed and accepted. By definition, water quality standards apply to water bodies. And that's important. It's not just water bodies, but it's any segment of a water body. At 40 CFR 130.3, a water quality standard defines the water quality goals of a water body or portion thereof. This board may not allow the degradation or impairment of any water body or any segment of a water body. It's not a watershed by watershed analysis, it's a water body by water body and each segment of that water body. Thus, the board cannot make valid findings as to compliance with water quality standards without assessing all impacts on the project in combination with one another. And the board must reject DEQ's attempt water quality related analyses and claim the Corps' separate regulatory measures will protect water. The Corps does not attempt to assure compliance with water quality standards, and it does not have the authority to do so. Only this board has that duty. Virginia's water quality standards are comprised of several elements. Among them are you have to protect the designated use of waterways, and you do that with the narrative and numeric water quality criteria that create existing uses and by application of the anti-degradation provisions. Remarkably, DEQ has not even attempted to analyze those elements, the essential elements of the water quality standards that you're charged with making sure are complied with. DEQ has not identified or assessed whether ACP will meet either narrative or numeric water quality criteria as required by the Clean Water Act. It has performed no assessment of how much pollution will end up in Virginia's waters as a result of the ACP. Not only has DEQ not provided any analysis as to why it believes the ACP will comply with water quality criteria, it has not even performed its most basic function to identify which criteria are relevant to that analysis in assessing potential impacts on water quality. DEQ has not conducted an anti-degradation analysis as required by the Clean Water Act. In addition to identifying relevant water quality criteria and assessing the likelihood that those criteria will be violated, DEQ has not conducted its anti-degradation review. That omission alone renders DEQ's draft Section 401 certification inconsistent with federal law and invalid. It is well established that the state's anti-degradation policy is part of its water quality standards. EPA has said, quote, quite simply, anti-degradation policies are part of the water quality standards, end quote. And the United States Supreme Court has held that, quote, state water quality standards are part of the federal law of water quality control, end quote. Accordingly, if a state fails to conduct an anti-degradation review before issuing a 401 certification, it acts inconsistently with federal law. Thus, to determine whether a federal permitted activity will comply with all water quality standards, the state must apply its anti-degradation policy to the discharges from the facility in the course of its Section 401 review. Virginia's anti-degradation policy, promulgated to comply with those federal requirements, mandates that the policy, quote, shall be applied whenever any activity is proposed that has the potential to affect existing surface water quality. DEQ has not performed any anti-degradation analysis for the discharges that will result from the construction and operation of the ACP. Such analysis requires, at a minimum, baseline water quality data for receiving streams and a quantification of the additional pollutants that the proposed pipeline would add to those streams. If that review finds that any Tier 2 stream or high-quality stream would be adversely affected, DEQ must then engage in an economic analysis to determine if such changes are necessary to provide benefits to the local area. Without such anti-degradation analysis, DEQ cannot make the required findings that it has a reasonable assurance that the ACP will comply with water quality standards. Recently, it sued the West Virginia Department of Environmental Protection for its failure to perform its anti-degradation review on the Mountain Valley Pipeline. In an admission of its failure, West Virginia had to ask the United States Court of Appeals for the Fourth Circuit to vacate its Section 401 certification for the MVP and remand it back to the agency for further consideration, rather than defend the certification in court. West Virginia's express reason for making that request was that it, quote, recognized that it needs to reconsider its anti-degradation analysis. In light of that requirement, applications must include an anti-degradation analysis. Can avoid running afoul of the anti-degradation law by taking the necessary steps before the and to do all the analyses required. It is remarkable to me that the DEQ would ask this board to certify the FERC certificate when it did the same as West Virginia to perform its anti-degradation review. Let me say something about anti-degradation. It's a critical part of the water quality standards, and it's even more stringent than just protecting existing uses means that the board can't allow a stream to become impaired. But the anti-degradation rules forbid degradation of the water, a lowering of water quality standard, even if the water doesn't become impaired. It's a critical part of the water quality standards, and I urge you to look at those carefully and think to yourself, has DEQ done its work to make sure that we are in compliance with those provisions before we issue the certification? Now remember also that we do not know how long an open trench variance will be here. That's because DEQ hasn't decided yet. Then please ask yourself, how can I today, sitting here, determine that these trenches, which I don't yet know the length of, will cause no degradation to water quality? How can I decide that today when I don't have that information? If you don't know, you cannot issue the certificate. Lastly, DEQ has essentially told us and told you that it's done more analysis here than it normally does. Well, it's always obligated to consider upland impacts because those upland impacts affect water quality. That erosion is the heart of what the water quality standards are about. And if DEQ has failed to do that in the past, I don't know what to say about that except it hasn't done its job. It has to do it. And the context for that is, do you know that in Virginia, I just discovered this last night, there are 21,000 miles of state streams and rivers that are on the 303D list. That means they're not meeting water quality standards. 21,000 miles. And the reason for that is because Virginia has failed to apply the water quality standards before it issues permits and before it issues certifications of federal permits. And I urge you, please, here, do not add to that 21. Shame on the state of Virginia, and we should be reducing that, not expanding it. Thank you.